Okay. Very good morning, everyone. From behalf of Padol University, Faculty of Commerce, today we are organizing a webinar series, online webinar on overview of intellectual property rights. We are glad to having today with us a CS Priyanka Dipesh Vargama as a guest speaker for the topic. If we talk about the profile of the CS Priyanka Vargama, Madam have completed their CS degree or pursue the professional course from ICI Institute, which is we know the Institute of Company Secretary of India. Madam have also pursued the LLB from SNDT University, Pune. Also, Madam have completed the bachelor degree from the Mumbai University. Madam is working as a manager currently in International Asset Reconstruction Company, which is also registered with the Reserve Bank of India. And Madam is working as a manager from last 5 years and handling the secretarial and legal role in these institutions or company. Other than this, Madam is also done their internship in RPG Life Science, which is also well known a pharmaceutical company, which is part of RPG group of companies. Madam have also attended a various workshops, seminars organized by the reputed institutions and the companies on the topic is related to the Companies Act and insolvency and bankruptcy code in the various cities such as Ahmedabad, Jodhpur, Ankleshwar, New Delhi, and Pune. Also, Madam have provided the various training sessions and various institutions to guide various companies related to all the topic. So we are welcome you all as well as we are welcome you, Madam, to our Padol University webinar series. Now we are handing over this PU webinar platform to you. Thank you, Madam.
Thank you so much, Mr. Mehul Vargama, for this kind introduction. So, good morning to everyone present here. So, I would like to start with the session. I'll just share the PPT first. So, is this the PPT is visible? Everyone can see it very clearly?
Yes, it is visible.
It is visible. Okay, so I can just start. So, as you everyone know, the topic for today is overview of intellectual property rights. So, we will begin with the topic. So, the objective of this presentation is basically to give a general introduction to this concept of IPR, because this is actually a old concept, but students have faced many problems in understanding the concepts because the types of IPR are very similar. Till you understand it, it seems to be similar. So that is why it's the basic objective is to get clarity on the concepts of IPR, and it is going to focus on the patents, copyright, trademark, designs, geographical indications, international treaties regarding IPR, and the intellectual property laws which are applicable in India. Okay. So we'll start with the kind of properties. So this is a type of introduction till we come to our main topic. So as you can see, the first thing is the property word is divided into various streams. So over here, if you see property, if I define property, it is the property. This word is derived actually from a Latin word proprietary and the French equivalent of that, which is properties. So basically the meaning of which is that it means a thing owned by a person or a institution. So if we see the property, if we usually see in our surroundings, we categorize many things as properties, okay, in numerous sense. If we look around ourselves, then also we find many things which we generally categorize as this is a property of someone, or this belongs to someone, or something like that. So now properties can be of various types. It could be tangible, intangible, movable and things. So further we can just so this basically what is exactly you do with a property. So what we do is a person claims his right, individual claims his ownership with all his rights on the property. So that is all about property. So we'll move further to the classification of property. That is in the classification is made under two heads over here, as you can see in the PPT. It's tangible and intangible. Now we'll understand what is tangible property. So what is tangible property? That is what can anything what you can has a physical existence. That means you can touch and feel the thing. That is a tangible property. Now it has these are basically types of properties which are used by the companies and all, you know, in their business operations and things, and also we use it in our day-to-day routine. So as you see, this tangible property is also divided into two different heads. That is, the first one is a movable property. So movable property, we all know the example is over here. So we all know that is easily can be moved from one place to another. So you can easily just take it and you can move it to another place. That is a type of movable property. So in this movable property, it has to be, you can move it from one place to another, but you are not going to change its shape, capacity, quality, or quantity in this movable property thing. Now the other is immovable property. So now the, as we know, the immovable property is the property which, you know, it's permanently attached to the land surface and it cannot be moved from one place to another. So the examples over here are given as land and buildings. So these are very basic concepts, but as it was going in the flow chart, I thought that I might explain you know, basic things about it. So now we come to the second side, which is the intangible side. So the intangible property is which does not exist physically. So there is no physical existence of this property and it cannot be touched or felt, but it represents a value. So it is not something, you know, which is if you cannot see it, so there's no value, but it has a good value in itself. So those are intangible properties. So now ownership of this intangible properties entitle the owner to enjoy the rights over it, similar to the tangible property. So if example, if you own a car and you are the owner of the car, so that is a tangible property, correct? But so you can, you know, enjoy its rights. Basically you can take it out, you can use it and all that. So those rights you have. But even though those intangible properties cannot be seen, touched, or felt, but then also they also carry the rights along with them. So the ownership rights are there. So now in this intangible property, the further classification is intellectual properties. So basically our topic for today is intellectual property, and we come to this topic. Now in this intellectual property, the examples are trademark, copyright, and things which we are going to see further in the other slides. So now now we will start with our topic, the intellectual properties. Okay, so what is intellectual property? So intellectual property refers to any intellectual creation of mind. So what exactly it is? So whenever a human mind creates any idea or any such, you know, thoughts, whatever human mind gets, and once that thoughts are, you know, actually executed or brought out, and then a design or a logo or trademark or any such process or a new product is invented. So that is something what is came out of the human mind. So that is the intellectual property basically. So now intellectual property laws give people the right to own and profit from their artistic, scientific, and technological creations for a designated period of time. So you do get rights on this intellectual properties, but that is every intellectual property has its own designated time period, and then there are certain renewals to be done or there are other processes to be followed. after that time period is over. So now this intellectual property is a product of human intellect, and it is intangible, as we have seen before this slide. So it is intangible because it is a product of human imagination. So whatever a human being has thought of, he has imagined of, and he has created this into a property, that is an intellectual property. The primary objective of this intellectual property is to encourage inventions by promoting their protection and utilizations. Okay, so and also to contribute to the development of various industries. So these are major, this intellectual properties are used in various organization, various industries, and all. So that creates a business value, it develops the industry, the organization, and things. Now, the example for IPs are invention relating to a product or a process. So there is invention when a totally new product is introduced, or a process is introduced, and new design of an article is introduced. As we see, there are so many articles, design things available in the market, or there is a literary or artistic work. There are many artists, singers, painters, and etc., etc. So they create their own work. So those are the works which come under intellectual properties. And there are trademarks. So there is a word or a logo, specific things on a products mentioned on the product. So those are all trademarks. That the types and other thing details we will see in the next few slides. So now, nature of the intellectual properties. So now this intellectual properties is nothing but a creation of human mind. So intellect. So this, as we have discussed in the earlier thing, that it is nothing but the human mind has created some ideas, had got some ideas, and that are actually brought out, and then there is a new thing created out of it. So it is creation of a human mind. So it is, the next point is, it is an intangible property. So intangible property, we have already seen this also in the previous slides, that it cannot be touched and seen. Okay, so it is intangible in nature. So the third point is exclusive rights given by the statutes. So there are certain, this intellectual properties have certain, the owners of the intellectual properties have certain rights given by the statutes. So they can basically use those rights. Statute means law. So these rights are given by law. Once you get your intellectual property registered with the concerned ministry and department, you get those rights automatically, and then you can use those rights. The fourth point is attended with limitation and exceptions. So as there will be rights coming along with your ownership to that intellectual property, but yes, there are certain limitations and exceptions. So the limitations would be that there, if you are going to register, so for certain intellectual properties, if you are going to get registered your intellectual property in a certain territory or certain region, then you can get protection only in that region. So if any person is going to some other region and using that your intellectual property, but then you cannot object in that case, because you have only taken the registration for this particular city or the particular region. So those are certain limitations, and there are certain exceptions also to the different intellectual properties. So the second last point is time bounds. Okay, so there are you take the registration, but the registrations are valid for a certain period of time, and then you have to go for renewal. So it is time bound basically. And the last point is territorial. So as I've explained in the limitation points, that certain intellectual properties are based on the territory. So if you belong to certain territory and you're taking a registration in the same territory, it gives you the protection only in the same territory and not in the other territories. So first we have seen intellectual properties. Now we are seeing the intellectual property rights. So what it is basically, so the intellectual property is the actual property, and intellectual property are the rights you get under the law once you get this intellectual property registered. Okay, so now over here, intellectual property right is a statutory right granted by the government to the applicant or owner of an IPR application. So basically, if you are getting your intellectual property registered with the government, then you have to, you get it for a certain period of time, and once you get your intellectual property registered, then you have this, the government gives you the right that other people cannot use your intellectual property, and they can there only you will be getting the exclusive right to use the same. So now the intellectual properties actually were rights were essentially recognized and accepted all over the world due to some important reasons. The reasons are, to provide an incentive to individual for new creation. So if a person is creating something new, so he will at least expect that he would get something, that he would not expect, but I think that the government thinks that there has to be some incentive given to the individual, so that these inventions and these IPR are actually useful to the society and the companies only. So there is no personal use of the creator or the owner of the IPR. So he's doing it for the society only. So the government thinks that there should be some incentive provided to the individual who creates the intellectual property. The second point is to accord due recognition to the creator and inventor. So now if I have created some IPR, so if I get it registered, and if I have, the government gets it, it displays on its website, there are the list of persons, the owners who have this intellectual properties and all. So the government basically thinks that due recognition has to be given who has created this intellectual property, whosoever creates the new intellectual properties. The third is to ensure material reward for intellectual property. So now today, if I have created any intellectual property, then I get it registered. It can be transferred, it can be sold, it can be leased, everything can be done on these properties, and I can get income, I can get material reward out of these intellectual properties. The fourth point is to make available genuine and original products. So basically what happens in is that if the person is creating intellectual properties, new and new intellectual properties, so then there are new and new genuine products coming out in the society, in the market. So that is actually the benefit to the society also. So now we will be looking at various kinds of intellectual properties. So as you can see over here, so these intellectual properties are divided into different parts, basically designs, trademarks, patents, copyrights, and geographical indications. So now one by one, we will see these things in detail. So first we'll start with the copyright part. So now copyright is a legal term describing right given to creator for their literary and artistic work. So now this copyright is basically related to this music and films and such things. So for the protection for the books and all. So for the protection of these, there is a copyright. So a copyright gives the creator of the original work exclusive right to it, usually for a limited period of time. That is always there in the intellectual property. So now copyright may apply to wide range of literary, artistic, creative, intellectual, or artistic forms of work. So as I told that it is, something which is artist has created it by its own mind, and something like paintings, there is some songs, and certain things, or some books written by some persons, all come under this copyright thing. So copyright does not cover any idea and information themselves. It's only the form or manner in which they are expressed. So for this, there is one example over here. There's a Shakespeare's play Romeo and Juliet. We all know about it. So if we say that this Shakespeare's play Romeo and Juliet has been copyright by the owner, okay. So but what happens? That this play itself, this name and the play itself is copyright. But if someone wants to this, we all know this Romeo and Juliet is a type of a love story type of thing. So if I say that some other theater is playing a similar love story, so that would not mean that they are, taking any thing from this Romeo and Juliet play. So that does not mean that they have copied anything or something. If they are using the same name, they are using similar word to word things, then that would mean. But if only the idea, so the ideas and information are not covered under copyright. Okay. And so the copyright comes into existence as soon as the work is created and protects skills and labor employed by the creator in the protection of his work. So that would mean all what I have already explained, that these are like all intangible assets. And one example for this, one more example would be, see, if there is a copyright to a song and the one company has recorded this song and they have the copyright for the same. So now what can happen is that if anyone else wants to play that song, because the company has, the one company already has the copyright of the same, and the other person, individual or anyone has to play the song, they have to pay a royalty each time when they play the song or use that song in any place. So this is how it works. So if you have the, because the company has the copyright, so it can ask for the royalty every time their song which has been copyright, so they can ask for the royalty for the same. So this is how, income is generated out of this intellectual properties. So now types of work protected by copyright. So now we will see what types of work are basically protected under this copyright thing. So there are literary works, which are examples over here are book, magazines, newspapers, technical papers, instruction manuals, catalogs, tables, compilation of literary works. So there, and the other is musical work or compilation. Okay. Dramatic work include, but not only plays, but also, for example, a sales training program captured under the video cassettes. Then there are artistic works such as cartoons, drawings, paintings, sculptures, and computer artworks. Photographic works, both on paper and in digital forms, are included for copyrights. Computer programs and softwares are also included under this copyright. Some type of database, if there is, it also can be included under this head of copyright. Maps, globes, charts, diagram, plans, and technical drawings are also included under this head. Advertisement, commercial prints, and labels are included. Cinematographic work, including motion pictures, television, shows, and webcasts are also included in this copyright head. And any multimedia products are also included in this copyright head. So basically, this is all about copyrights. Now we move to the next type of intellectual properties, that is patents. So now, a patent is an exclusive right granted for an invention, which is a product or a process that provides in general a new way of doing something or offers a new technical solution to a problem. So now over here, basically, we will first try to understand what it is. So example over here is a pen with a scanner. So prior to that, we had normal pens. Okay. So now there was a new process introduced, wherein in a normal pen, they had added a scanner. So they had added a scanner. So that's a new process in this. And out of that, they also got a new product, which was a pen with a scanner. So now this process and the new product, that is a pen scanner, and the process of making the pen, turning the pen into a pen scanner, they both can be patents, so that any other company cannot, or any other person cannot use the same process or similar product cannot be made if we have patent, the owner has patent this pen. Okay, so now patent is basically a monopoly right given by the government to the investor for a period of about 20 years. Once granted, patent gives the investor the right to exclude others from making, using, selling, importing, or offering for sale for the inventor's invention. So as I told that the person, if the company who has created this pen for the first time, a pen with a scanner, gets the itself patent, gets the patent registered on its name, then no one else can make, no one else can use the process, no one else can sell similar pens, no one else can import it or even sell it without the permission of the owner, basically. So after, and there is one thing in this, once this 20 years of period of patent gets expired, then if the owner does not go for renewal, then the patent will fall under the public domain, and thereafter anyone can use the invention. So the owner has to be very alert while once the period what is granted on initial registration, if that 20 years is getting over, it has to immediately apply for this renewal and get it again on its name. Otherwise that goes in the public domain, and once it goes into public domain, then anyone is in public domain, anyone is free to use this invention of the owner. Okay, and these patents are basically these inventions can be any new article, composition of any matter, machine, or any process, or any new value addition to the existing. As we have seen, this was a normal pen which was invented prior, but in this pen, they have added a new value by adding a scanner and making it into a new product. So patents are territorial rights, which means if the invention, as I told you in the prior slides, so if the inventions is only protected in one country or region where the patent protection has been obtained, then it is very difficult to get your patent. If any person use it in the other country or region, then you cannot object to it because you have not took any protection in that country or region. So that is the thing. And in that country or region where you have not gained protection, other people can use it, sell it, import it, or do anything with your own invention. But if you have not registered your patent in that region or country. So and invention is a solution. So this patent is basically inventions, based on inventions only, new inventions. So invention is a solution to a specific technological problem, which may be a product or a process, and generally has to fulfill three main requirements to come under the category of the inventions for the patents. So the first one is it has to be new. So it has to be something new invented. Invention means itself, it should be something new. The second point is not obvious. So not easy, it has to be something which is not easily discovered, seen, or understood. So the invention has to be something new. If you say today that I have invented this new pen, but pens are already available, not with a scanner, I'm talking about a normal pen. So if you say I have just designed a new pen which is something different from outside, so that cannot be a patent in itself, because you need to have something which is not easily discovered elsewhere, and it is something new basically. The third point is there needs to be an industrial applicability. So that would mean that invention can be made or used in any kind of industry. So the invention should be such that it can be used by everyone, or at least by every industry, I would say. So now to enrich the body of knowledge and stimulate innovations, it is the obligation of the patent owner to disclose valuable information about the invention to the public. So how it will come to the public, how he will disclose to the public is when a patent owner is applying for registration of a patent, so while applying there in the registration form, he has to disclose each and everything about the patent in the form, so that later on it is all available on the intellectual property website. So we have a intellectual property website for our India, and there where you can get all the details of all patents and trademarks and everything what is registered with their owner's detail and all. So the owner has to provide the details while he is getting the patent registered. So now we'll move to the next slide, that is inventions not patentable. So there are certain inventions which cannot be patented. So those are discoveries and scientific theories, so that cannot be patented. There are scheme, rules, and methods for performing mental acts, so that is not patentable. Mere discoveries of substance as they naturally occur in the world. So there are certain things which have naturally occurred in the world. So like it rains naturally, so the sunlight is natural, so those things cannot be patented, that is naturally which has come into the world. So invention that may affect public order, good morals, or public health. So there are certain inventions, if it is affecting good morals or public health, those cannot be patentable. So the diagnostic, therapeutic, and surgical methods of treatment for human and animals. Okay, so there are certain treatments, surgeries, so those cannot be patented basically. So we will move to our next type of intellectual property, that is a design. Okay, so now over here you can see certain images, and if you see there, the design means only the features of shape, configuration, pattern, ornament, or composition of lines or colors applied to any article, whether in 2 dimension or 3 dimension, or in both forms by any industrial process or means, whether manual, mechanical, chemical, separate or combined, which in the finished article appeal to and are judged solely by the eyes. So now what it is basically, over here you can see the image of the shoes, you can see the image of certain men's wearing different types of clothes, colors. You can see an image of a sandal and a heel over here on the right side. So these are the designs. So these are, you can see they have made a sketch of a design of that shoe. So they get registered, these designs, with the intellectual property website. So these designs are like, the once this design is made, then they get it, this design is registered, and no one else can make such type of design. Further explaining this design, so these designs are creative activity which result into ornamental or formal appearance of a product and designs. So for this, basically this industrial designs are the product design. So we have certain examples further which will help you to understand more about designs. So now the next slide is essential for the registration of design. So there are certain things which has to be present in order, if you want to register your designs, has to be certain criteria to be fulfilled, then only you can go for registration. So over here, if as you can see, the design must be new or original. So every time the design has to be new and original. It must be it must have visual appeal, so it should be seen properly. It should not have been published before filing. So you cannot just publish it first and then you go for filing. No, it has to be filed first, and then you can publish the design, or you can make the product out of it and then use it. The design must be significantly different from the known designs. So if you see, there are certain shoes. First, we have seen in the prior slide the picture of shoes. So there are so many types of shoes. If today I am getting myself one design registered, then I have to make sure that it is not matching to, there are so many shoe companies in the market, in the shoe industries. So I have to make sure that my design is different from their design. It should not be similar. So, and it should not comprise or contain any scandalous or obscene matter. So there should be no such designs which would result into any scandals or scams or something like that. It should not include a trademark or a proprietary mark or an artistic work. So this design should not have any mark, trademark, or any marks such. Trademark, we are going to take it in the later slides, but I'll just explain it like that, that it should not have any words or anything mentioned on this designs representing, those words are of other company, or it would represent some other company or something like that. It should not, conflict with any other product or so. And a design should not include any mode or principle or construction or anything which is in substance a mere mechanical device. So it should not be just a mere mechanical device. It should be a proper design. So now we'll move towards our next topic, which is trademarks. So now, trademark is basically a unique sign or indicator used by an individual, business, organization, or legal entity to identify that the product or service are offered to the consumer with which the trademark appears. It would have originated from a unique source of origin in order to distinguish its product or valid for service for those of other entities. So now, basically, in a normal language, I would like to explain that a product of a competitive economy, where more than one person compete for the manufacturing of the same products, which is necessitated by the market. So what happens is they are distinguished with the help of a symbol, or when, as we know, if we go to buy any particular soap, so in market there are so many types of soaps available. So what, as a company, what I have to think is, if I want to make my product look different, so I have to give it a different name, I have to give it a different color, a different basically wrapper and everything, in order to get distinguished. Because in any industry you step down, there are so many products available of the same kind, so many products available. So these trademarks are basically, any word, phase, logo, symbol, design, image, or a combination of these elements in order to make your product different from others. So here we can see some examples are Coca-Cola, IBM logo, and Airtel logo. So we can see this. These are the logos. So we are very well versed with this. We have always, while taking this Coca-Cola bottle, we can see this logo. So IBM, we might have seen somewhere. Airtel, we have seen, many of people might be using this Airtel SIM cards and all that. So you might be aware of this. So these are all trademarks. So the companies have got these logos registered as their trademarks. Once they get it registered, they can use it. So now we'll go to the types of trademarks. So here you can see various images over here. Okay. So in types of trademark, first is a word mark. So word mark is basically that is used to identify the product and services of a trading company or a service providing company. If your name of a product, or it is basically is the name of the product or a service is text based form, contains only text, and this type of thing will be registered under the word mark. Over here you can see the example of Nestle. So this Nestle, the first one, Nestle is the example for a word mark. So because over here they have written the actual text. So the name of the company is Nestle, and they have taken their name in some different font to get their trademark registered. And they have, in all the Nestle products, you would find this trademark on their products, so that the consumers know that this is a product from Nestle. The second is the service mark. So the service marks represent the service which a company or a business deals in. So now over here, the example given over here is FedEx. So FedEx is basically a registered courier delivery service provider. So the service mark is you belong to a specific service industry and you have that mark of that service industry, and that you make that mark is made as the logo of your company. The third is logo and symbols. A logo is printed, painted figures, designs, characters, and all. Basically, this is, if you see this example for logos and symbols, that is this Apple is registered logo, and on every product, on every Apple phone, iPhone, yeah, everything, or any products of Apple, you will find this. So this is a logo or a symbol which has been registered as a trademark for the company. The next is the shape mark. The shape mark would mean the shape of a good, appearance of a product. So the label of the product can be distinguished based on its packing. So now over here you see the Coca-Cola bottle. As we have earlier also discussed about this Coca-Cola bottle. So over here, if you see for the shape mark, the bottle shape, the outside, the shape of the bottle has been, registered as the trademark. So now the name is registered. The Coca-Cola name is also registered as a word mark, and the shape of the bottle also they have additionally got it registered under trademark. So that is based on the shape. So no one can copy the shape also of the bottle. The next is collective trademark. So now this collective trademark would mean that marks are linked with a group of people and not a single product or a service. These trademarks are primarily owned by the organization, institute, and association. So you can see over here, there is a mark of a chartered accountant. So they use this logo, all the chartered accountant, it's not only one person can use, but whosoever is a chartered accountant can use this logo. So there are similar logos for company secretaries also, and there are similar logos for cost accountant also. So these are the marks which all the people, all the members of the institute whosoever is a chartered accountant, company secretary, or a cost accountant can use this logo. So it is, that is why it is known as a collective mark. Now the last is certification marks. So these are like if these marks are created to show a specific quality standard of the company, basically whether the company has met the quality standards or not. And the example for this is the Food Safety and Standard Authority of India's mark, which you will actually find in the packed food products. Whatever you purchase, we can find these marks in that. I think so. This trademark is clear. We will now go to the next topic, which is geographical indications. Now, in this, geographical indication is an indication which identifies goods as agriculture good, natural goods, or manufactured goods as originating or manufactured in the territory of a country or a region or a locality in that territory, where a given quality, reputation, or other characteristics of the good is essential attributable to its geographical origin. So now let's not go with the definition, but let's go with the examples that would help you to understand this better. So the over here example is basmati rice, Darjeeling tea, Nagpur oranges, Kolhapuri chappal. So the if you take the example of Darjeeling tea, so this tea has come from Darjeeling and it is named as Darjeeling tea. So this belongs to a very geographical indication would mean that it is from Darjeeling and it is the specialty of Darjeeling, and in the way it is named as a Darjeeling tea. So they get it registered, this geographical indication, as Darjeeling tea. So these this Kanjipuram saris, so they are from Kanjipuram. So they are also registered as a geographical indication. So the main benefit over here of geographical indication, the getting registered, is that it prevents unauthorized use of these by any other person. So geographical indication is just, it belongs to a certain geographical area and it gets its name, and then you get it registered according to the geographical region. So now IP laws of India. So we have seen 5 IP laws today, intellectual properties today, sorry. So these are copyrights, which the applicable law for it is the Copyright Act 1957, which is, and the concerned ministry is the Ministry of Human Resource. Then patents are, the applicable act is Patent Act 1970, which was later amended in the year 2005. Then it is design. The design, it is covered under the Design Act 2000. The trademarks are covered under the Trademark Act 1999. And the geographical indications are covered under the Geographical Indication of Goods Registration and Protection Act 1999. And the ministry concerned for patent, design, trademark, geographical indication is one. It is the Controller General of Patent Design and Trademarks under the Department of Industry, Industrial Policy and Promotion, Ministry of Commerce and Industries. I think so this is fine. We can move to the next slide now. So now this example would help you to understand more of the topics which we have covered. So this is, if you see this pan, so there are patents and industrial designs both in this. So this is some different design which they have added. So they might have taken industrial design, design registration over here. They have the process under the patent. Same with the phone. This is the iPhone. So they have the trademark logo over here. They have this making of the phone, the process they might have patent. Geographical indication example is the Tirupati Laddu. So this is, the Laddu is famous in Tirupati, and that is the geographical indication. You see this, the process, industrial design for the bottle, trademark, the logo, and trade secret is okay. Geographical indication, Kolhapuri Chappal. This is from Kolhapur and it is famous over here. So I think that this example would help you to more understand what we have already discussed. We'll move to the next slide now. So now in this one bottle of Coca-Cola, we can find so many of intellectual properties. So this is the example logo. The bottle shape is industrial design. The patent obtained respecting bottle equipments and all is the patent. Copyright, the text-based artistic work, if any, on the website. And so there are 4 intellectual properties registered for this single bottle of Coca-Cola. Now a single product can be protected by more than one intellectual property. Okay. So now this is a table which shows the validity of intellectual properties. So the patents are 20 years, renewal is to be done every year, mandatory. Trademark lifelong, renewal after 10 years. Designs 15 years, renewal after 10 years for next 5 years. Copyright 60 years, renewal not required. Geographical indication lifelong, after 10 years you have to renew. Now patent we seize and be transferred to public domain, and patent are not renewed within 6 months of the expiry date of the concerned year by paying the renewal fees. So you have to renew it. You get after 1 year is expired, you get more 6 months as a grace period. If you don't do in the 6 months, then it goes into the public domain. We will move to the next slide now. So now this is just a comparison table from the intellectual property website. I have just took out this table where you can just see, how many intellectual property applications have we filed in since 2015 to 2020. So this is just a comparison table. Every year, how many applications are filed for registration. Okay, so we'll move to the next slide. So now we have just seen the intellectual properties. Now, why should an intellectual property be protected? So this intellectual property rights are valuable assets for a business, possibly among the most important ones it possesses. So at times, if the company is into the pharmaceutical business, then these trademarks and things are very important for them. So these intellectual properties are more important for them. So protection for them is very important. So if I am I'm a pharmaceutical company and I am suppose manufacturing a crocin, and some other company is coming and it will take similar name and the same composition, it is just going to change, crocin, from the spelling of crocin, it will only change few letters, but it will be very similar. So then people will get confused and they will take that medicine instead of the real crocin. So that is why, so for certain companies, for certain industries, this intellectual properties are very, very important to them. So now the protection of IPs can set a business apart from the competitors, as I have already explained you before. Can IPs can be basically sold or licensed, providing important revenue stream. That also we have discussed, that if the person has a song, the company has recorded a song, and if anyone else is using it, the other person has to pay royalty to the company who has recorded the song. So now the intellectual property protection has become more and more important nowadays for highly featuring scientific and technological improvements and establishing an efficient intellectual property system. Okay. So now basically these are for protection. These protection are to be there because many industries and many companies are such that they have these intellectual properties as their main properties, which they use in the day-to-day businesses. So now there are certain international treaties. So if if there is any company which is having business all over the world, and they are dealing into the products internationally, so there are various treaties which are there for the protection of intellectual properties. So there is a Paris Convention for Protection of Industrial Property 1967, which was later amended in the year 1989. So now this Paris Convention is like basically it is for the protection of industrial properties, trademarks and patents. So it helps to avoid unfair competitions among the members who have signed these treaties. And this is governed by the domestic legislation, means there are local laws which govern these basically treaties. So there is the next one is the Berne Convention for Protection of Literary and the Artistic Work 1971, which was later amended in the year 1990. So now what this convention says is it is basically for the protection of literary and artistic work, and it is governed by the national legislation, so that this is governed by the national laws basically. The third one is the Patent Cooperation Treaty 2004. So now this Patent Cooperation Treaty is like when you file a single patent application and designate the countries in which the application want to be you want to protect the invention, then this becomes easier. So if you are in a certain company, in a certain country, and you want the protection in all other countries which have signed the treaty, have signed under this Patent Cooperation Treaty, then it is very easy that in that one form only you can get protection under with all the other countries which are in this treaty basically. So this becomes easier, and this is governed by the international legislation, that is the international laws. Now the last one is a bit important, and the treaty name is Trade Related Intellectual Property Right, which came into force in the year 1995. So it is the important agreement of WTO, that's also called as a TRIPS agreement. Okay. So now this agreement came into force on 1st January 1995, and this TRIPS agreement is the international agreement administered by WTO, and it sets down the minimum standards for many forms of intellectual property regulation. So this was set down for there were certain minimum standards laid down in the agreement, which all the countries who are associated with this treaty have to follow, and this is basically for the protection of intellectual properties. So this agreement is till date the most comprehensive agreement of multilateral nature of intellectual property. So this is like the most comprehensive agreement till date, and this agreement has 7 parts documents in this, and all are related to the intellectual property rights only. So now the areas which are covered in this this agreement are basically the copyrights and related rights, which would include like, rights of performers, producer of sound recording and broadcasting organizations. Then it includes trademark. So it's includes all the types of trademarks which we have seen. It also includes the service marks. So then it includes the geographical indication, including appellation of origin. Then it will include patents, layout designs of integrated circuit, undisclosed information. Okay, and this now the last thing is the agreement governs issues related like application of international IP agreement, basic principle of trading system, advocate protection of IPRs, basically advocate enforcement of IPR by member nation and their treaties, settlement of disputes among the members of WTO, and if there is any other special transaction arrangements, and then it looks up after all these things. So with this, I conclude my topic, and this topic is really very vast, but I tried to cover the things I could, and as such there is no end to the topic, but that's it, I think. So I've tried to cover the maximum I could and the basic things which a student need to know. Thank you so much.
So thank you so much, madam, for accepting our invitations on short time. So now it's a time to propose a vote of thanks. So it's an immense pleasure to propose a vote of thanks on behalf of all students and staff of Department of Commerce and Parul University. I'm glad to be standing here to express my vote of thanks. A special thanks to our guest speaker, CS Priyanka ma'am, for expecting our invitations and for being here with us in PU webinar series. Your thoughts and rich knowledge have truly inspired to our students and staff. So thank you so much, madam. Once again, thanking you.
Thank you so much.
Okay, so now, ma'am, you can leave. Okay. Screenshot ready?